Hi, everyone. Carl Steinbeck. Just want to jump on tonight, talk about something that is really important. It's very crucial as a prosecutor and also defense attorney to not only know the charge and the elements of each charge that you would indict someone with, but also if you're a defense counsel, you need to know the jury instructions. The jury instructions can make a big difference in how a case is sized up, and it can make a difference between winning and losing if you're defense counsel, and you could lose the case to a prosecutor if you don't understand the law. And so, a lot of prosecutors make the mistake of just looking at the actual charge that they can pursue based on the evidence that's in a police report. But what they don't do is look at the jury instruction, which could have some type of an affirmative defense, which is also something that's a complete rebuttal to the government's otherwise good case. Um, and so that's sort of like if there's an assault charge, you have to look at self defense. So self defense can have be a complete defense to someone otherwise assaulting someone else. So anyway, so what I was doing is looking at the jury instructions in Massachusetts there because I'm looking as Judge Cannone's reading off this script for each of the pool of jurors that come in there, and she's talking about reasonable doubt and what it means, and she's talking about how it's hard to define. That's very troubling for me to hear a judge say that reasonable doubt is hard to define, but more easily understood. So I'm like, well, why don't they just come up with a better definition? So anyway, I was looking at what it was for reasonable doubt in the Massachusetts jury instruction, and I'm like, what a convoluted mess. And I mentioned that the other live stream that it is a convoluted instruction, and it's something that's been around for a long time. In fact, I was doing some research on it, and they've had that kind of instruction since the 1850s, and it's some kind of long explanation by somebody that's got a lot of word. A lot of words instead of keeping things simple like we should in the law. This is somebody that made it more academic and try to make it more lofty and hard to understand and follow, and in fact be confusing and contradictory. And so this is something I will say is not that's up to Judge Cannone. This is like standard jury instructions for Massachusetts. So she's actually following something that's followed by all the other judges, unless they decide to go off script. But yeah, and she even said that as you're saying here, special KL, you're saying she'll teach the jury the law. Um, and so I've never heard that before either. So she's saying that to all these prospective jurors. And so yeah, it's like a word salad. I agree. It says Dusty Blue here. So I thought we'd talk about that here tonight. Not too long of a discussion here, but there's a lot of terms that can just add to a lot of confusion. And I think ultimately this is something. If I'm in this jurisdiction, if I'm like an Alan Jackson coming in from out of state, and I'm going to a state like Massachusetts, and they got some kind of hot mess jury instruction like this on reasonable doubt, and I can't get the judge to change it, then I'm basically going to be really crafting in a lot of language and explanations of what reasonable doubt is. Because if you don't get this nailed down right, you could have otherwise a great case from the defense perspective. But if the juries don't get reasonable doubt, and as we heard from like that one juror that spoke out, and they didn't know what reasonable doubt was, and they thought basically the defense was there as a distraction. So those are very troubling things that they don't even understand the law. And when you have the judge saying that basically it's hard to understand, you sort of know what it means along those lines. Then it it just breeds confusion and allows the jury to just do whatever they want. They can basically toss reasonable doubt instruction, just do what they want, and basically act on what they think. Do they think the defendant is guilty? Well, you can think a lot of things as a juror, and but as to the defendant, you have to have proof to back it up. So you could have 12 jurors that absolutely think that the defendant is guilty, but unless they've proven it beyond a reasonable doubt, you're supposed to acquit, right? You're supposed to find them not guilty. So let's take a look at this now. And this is what we get off of Massachusetts. You guys can just Google Mass, MASS, reasonable doubt jury instruction. This is what'll come up. So this has been highlighted for tonight's viewing. And look what we have here. Let's see. This is a definition that the judge reads off the script, and this is also her intro script. Some of these terms are used as well. So it says here, the burden is on the Commonwealth to prove beyond a reasonable doubt the defendant is guilty of the charge or charges made against him or her. What is proof beyond reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. I mean, what kind of a jury instruction is this? This is like really bizarre to say that the jurors probably understand what this means, although it's not even easily defined. Is this sort of the things that the jury probably knows all the standards of law enforcement, crime scene investigation techniques and tactics and standards of proof in collecting evidence to use in a trial against a defendant? I mean, probably pretty well understood. Why is this sentence even in there? And even starting out with what is proof beyond a reasonable doubt, why don't they just go ahead and jump in there and find it rather than putting a big question mark in there like, hey, this is a really something that people don't understand, and let's try to explain it and walk you through it. So why don't you just come right out and say, this is what reasonable doubt means. Reasonable doubt means, you know, and so what they have here by saying it's not easily defined, my concern is that jurors look at this and say, well, you know what, the judge said it wasn't really easily defined, but we sort of understand it, so let's just run with what we understand it to mean. And that's not what you want a jury to do. You want them to be specifically honed in. Every word can make or break a case. You can win or lose a case based on one word. Okay, so whether it's been trials that you're doing in crim law, civil law, whether it's federal contracting that I've done before, I've always honed in on the fact that, and I saw this as like a brand new attorney. I saw somebody lose a case because they had one or two words wrong in a charging instrument, and the indictment basically made him drop it from a felony down to a misdemeanor because he didn't have the wording right. So what you need to do is focus in on these key words and really think, are they really lending an explanation that's understandable and clear to the jury? So let's go on to the next sentence here. So that whole first two sentences really could be thrown out, especially the second one in this paragraph, the second paragraph. So proof beyond reasonable doubt, it goes on to say, does not mean proof beyond all possible doubt. What are they defining what it doesn't mean? I mean, this is like so bizarre that without even defining it first, they say what it doesn't mean. So how's that supposed to help clear up the mind of the jury? So you're thinking, okay, you're waiting to hear what reasonable doubt is as a judge is reading this off. And she's saying what it doesn't mean. Okay, so why don't we first learn what it does mean before you start putting all these qualifiers on it? So it does not mean proof beyond all possible doubt. Okay, now we're talking about possibilities and all possible doubt. Those are operative words. Beyond all possible doubt. What if it doesn't mean that? Then they're supposed to think about it in the positive sense. So it's just very confusing to try to have a common understanding of this among 12 jurors. And then it goes on to say, for everything in the lives of human beings is open to some possible or imaginary doubt. How does this help any members of the jury understand what they're talking about? So the sentence before saying it's not easily defined, and now you're talking about things about possible doubt or imaginary doubt. We still haven't gotten to what reasonable doubt is. So I think this is opening the door to them thinking, well, is it reasonable? Is reasonable mean imaginary? We haven't heard what reasonable means. So maybe reasonable means possible. If it's possible, is possible on the same level as reasonable? We don't really know. So it's all convoluted, hot mess this far. Then let's go on to the next sentence, which says a charge is proven beyond reasonable doubt if, after you've compared and considered all the evidence, you have in your minds, they're saying in your minds, an abiding conviction to a moral certainty that the charge is true. What does this mean? In your minds, an abiding conviction to a moral certainty that the charge is true. Well, what does it talk about if the evidence is proven that the evidence is proven in such a way that you have no reasonable doubts about anything other than the fact of what the government's saying? That's not what this is saying. This is like you've so they're starting to talk about what reasonable doubt is. So they're saying a charge is proved beyond reasonable doubt if, so they're sort of trying to define it here now for the first time. After you have compared and considered all the evidence, you have in your minds an abiding conviction. Okay, why are you using the word conviction? Um, that says something because the prosecution is asking you to convict somebody by a criminal charge. Now they're using the word conviction like it's a conviction in your beliefs. Conviction normally be good there, but I think conviction here could be, you know, along with an abiding conviction. And then they add this whole thing about to a moral certainty. What does that mean? To a moral certainty that the charge is true. So then they have to define these different terms, right? No, they go on to the next one where it's in blue and they only define what moral certainty is. So what's abiding conviction mean? And then what about the charge? The charge is true. But one of the biggest problems I have with it is that it says have in your mind. So keep in mind what I've said about as a prosecutor, I want to not only just make it where the jurors think that the defendant is guilty, but there's actually proof to back it up, right? So if you had a scenario like what we have here in the Karen Reed case with Massachusetts, there's a lot of folks that are talking about saying, hey, something went on in the house. There's people in the house that must be responsible for this. And so if there's other possible actors that are responsible for John O'Keefe's death, then how does that play out in their minds, and what are they supposed to do with that they have doubts about it? So there's not a whole lot being said about how to process the evidence and the elements. So again, it just says it's proven if you've compared and considered all of the evidence in your mind. So it's not so much a mind thing. Again, if you talk about it's not just in your mind, it's got to be what the government has proven to your satisfaction, so you don't have any doubts about it that are reasonable, other than the fact of what the government's telling you happened, and proving that through the testimony and whatever kind of evidence they present to you as a juror. So, and then you have this moral certainty. So let's go on to this here. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. So, all right. So now this is defining moral certainty. What about abiding conviction? We don't have any definition of that. So how does that relate and tie along with or not tie along with moral certainty? So it's saying here we mean the highest degree of certainty possible. There again, the words possible. Okay, what's possible mean? In matters relating to human affairs based solely on so they're having sort of like two definitions here, part A and part B for moral certainty. We mean the highest degree of certainty. And what's certainty mean? Uh, so they're using certainty twice here. So moral certainty means they're describing moral certainty by describing certainty without the moral. So my moral, I guess they're trying to say we mean the highest degree of certainty possible in matters relating to human affairs. Okay, so that could sound like a high standard. Okay, a high standard of moral certainty. You morally are convinced that the person's guilty, but they go on to say based solely on the evidence that has been put before you in this case. So moral, I guess the word morals has evolved over time. So what moral means in 1850 compared to what it means nowadays today from among folks that are on a jury, it could mean something different and it could confuse them. So this is why if they're going to have this instruction, they really got to break this down and explain these terms and then tie it in with the evidence and explain why. I assume Jackson's going to do the closing, explain what these terms mean and tie it into how if you think somebody else did in the house, that's you're not morally certain that Karen did it. If there's more likely scenarios other than what Karen did, that's reasonable doubt, or you don't have a moral certainty that Karen did it. So that's the kind of thing that the prosecution is going to try to focus on some of these other things that are maybe confusing and in essence not have the jury focus on the strongest language of this very lengthy, convoluted explanation, and the defense needs to focus on the parts that do give it some weight. And I think last time there was only 3 times Jackson made reference to reasonable doubt. So I think they really need to drive that home this time. I mean, half the closing should be about reasonable doubt and weaving in the evidence and what all the indicators are of reasonable doubt. All right, next we have here the explanation. This is the 3rd paragraph. So they didn't keep it short and sweet. We're now on to a 3rd paragraph, folks. And so the judge would be telling the jury, I've told you that every person is presumed to be innocent until he or she is proved guilty. Why don't they say proven guilty beyond a reasonable doubt, and that the burden of proof is on the prosecutor? Okay, that part of it is fine. The burden of proof is solely on the prosecution. It does say, they're not talking about the defense has no burden to present anything, although that's another instruction that could be added here. If you evaluate all the evidence and you still have reasonable doubt remaining, the defendant is entitled to the benefit of the doubt and must be acquitted. So the stuff in red they're entitled to, it's like, oh, hey, we're going to give the defendant a favor. They're entitled to this, but it's not that big of a right. It's not that significant. I just don't like the word entitled to the benefit of that doubt. And then they say, and must be acquitted. Well, what does acquitted mean? And must be acquitted by whom? Who's supposed to acquit the defendant? It doesn't say. It doesn't say on the next page, I might add. So you got words like the defendant is entitled to the benefit of the doubt and must be acquitted. So why don't you make it stronger and say the defendant must be found not guilty? That's one way to make it shorter and sweeter. If you still have reasonable doubt remaining, the defendant must be found not guilty on your verdict form. So it's just too much word salad here. Let's go on. And look, here you got another paragraph. My gosh, we're still not done. It is not enough for the Commonwealth to establish a probability, even a strong probability. Okay, now we're back into probabilities. That can be very confusing and misleading for a jury. Do they really need to know probabilities? Is it really like you can really mathematically describe what beyond reasonable doubt is? I just think it's more likely to confuse the jury. What is a strong probability? I mean, we could all disagree on that. No one's going to agree on what a strong probability is. It was a strong probability, a 60% chance, a 90% chance, a 99% chance, 70%. It could totally vary from person to person. And then it says here, a strong probability that the defendant is more likely to be guilty than not guilty. Okay, so that sentence starts out by saying it is not enough. And so it's like they're trying to tell you it's a higher burden than what you think it might be. I mean, they're saying that's not enough. The burden's higher than that. But, throwing all these terms out there, it just really, I think, is just going to lead a juror to be more confused than anything. And then it says, and then that is not enough. So it goes from it is not enough to that is not enough within those 2 sentences. And then it says, instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty. Well, now we got a new definition introduced here. Defendant's guilt to a reasonable and moral certainty. So we heard moral certainty yet again after we already heard it, and they described it in those convoluted terms. And now you got reasonable. So the evidence must convince you of the defendant's guilt to a reasonable certainty. Well, is a reasonable certainty less than a moral certainty? Because it looks like reasonable really undercuts the moral part of it. If you go back to what it was here on slide before it, it's like moral certainty. That's talking about the highest degree of certainty possible in human affairs. And then you have here a reasonable and moral certainty. So what's that mean? Are we now taking away what that was in the previous definition? And then it goes on to say a certainty again. Well, is this certainty less than the moral certainty? And what about the reasonableness part of it? I mean, this is the way this can all be sliced and diced and just really lead you confusing. A certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. So, all right, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who, oh, right there, let's just stop at judgment. A certainty that convinces your understanding and satisfies your reason and judgment. What does that mean? Can anyone describe what that means? If you ask the jurors to tell you on voir dire what that means, if you're allowed to question jurors, which is certainly probably not allowed much in this case by Judge Cannone, it says, "Oh, a certainty that it convinces your understanding." How do you convince your understanding? A certainty, so that's a moral certainty, so that's internal to you, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act consciously on the evidence. So now there's a consciousness part of the evidence. And how's that tie in with moral certainty? And how's that tie in with your understanding and reasonable certainty? And how's that tie in with the reasonable and moral certainty? So it's just a hot mess, very convoluted, very disjointed, very fragmented. And to have all this in a 1 hour closing, yeah, this is why they don't want more than an hour. The judge doesn't want more than an hour in the closing argument. I mean, you got to weed through this stuff and really explain it well. And then it goes on to say, this is what we mean by proof beyond reasonable doubt. So, um, anyway, this is so much a tough thing to deal with as a defense attorney, because it's like, how do you explain this? How do you weave through all this on what all these terms mean from the 1850s? And it's really not really something that you can hang your hat on and really give a good explanation on this. So I would say, as a trial attorney, I'm going to bring up some of my own explanations of what this means. So I would equate it maybe to a football field. And I've said that before. It's like you're starting out in the back of the end zone, and as a prosecutor, and you got to drive it all the way 125 yards for a touchdown. That's what beyond reasonable doubt is. And through the end zone, and more than 125, you got to go back basically behind one goalpost and go past the other goalpost. That's how much the burden of proof is. And and that's some way I think jurors can equate to this. And I think it's been a good thing in my many trials. But here, this thing, I've never seen anything this this confusing. So, and then you go, this is not even going through the verdict form, right? So you got this hot mess confusion on what reasonable doubt is. This two words, reasonable doubt, causes you to have to write a page and a half describing what it is. And even this leads you more confusing. So it is not easy to define. You made it as confusing as possible. So going back to the term is often used and probably well understood. Well, the jury would understand it if you didn't even talk about it, but you introduce these terms, and now it's just a jumbled mess. So, Brick Chick, you're saying this is why they were so confused and left their own devices last trial. Yeah, I mean, this is what it comes down to. You hijack the whole process, a due process, by having this kind of instruction. And this instruction, there's a similar one I've found, and there's like some Supreme Court case law I found one that had similar language to this, and the argument was, well, this is so antiquated. Jurors nowadays don't understand it. And this is back in the 90s, so Supreme Court case, Vickers v. Nebraska. And it's like this is like even more so today, really hard for people to understand. It should be simple, concise. And the Supreme Court, I think, if this was challenged in Karen Reed's case, I think they would find that, yeah, this jury instruction is very, very much failing to meet due process standards guaranteed under the Constitution and applicable to states through the 14th Amendment. So, So I would say this is something that I don't know what the shot is of an appeal, but it's something I would certainly raise on appeal, and I would do my darndest to make sure this is something that's going to be brought up and raised on appeal if there's a conviction. I don't expect a conviction. I think the evidence here has so many things of reasonable doubt that there's no way Karen Reed should be found guilty of any of these three charges. So what I did also is I pulled a federal case here out of the Houston district area. And so we're going to go to that here. So if I can make this even larger. Okay, here we go. Okay, so slide 2 here, it talks about under Charlie's presumption innocence, burden of proof, reasonable doubt. So they have all these things sort of like rolled in here, really a tight shot group. And then it starts out by saying it's only required that the government's proof exclude any reasonable doubt, quote unquote, reasonable doubt concerning the defendant's guilt. So before that, it says, while the government's burden of proof is a strict or heavy burden, it's not necessary that the defendant's guilt be proven beyond all possible doubt. There they use the word possible again, but at least it's not used multiple times, multiple different ways. It is only required that the government's proof exclude any reasonable doubt concerning the defendant's guilt. So, okay, if you have reasonable doubt, if the government can't prove it without you having a reasonable doubt, then obviously the government's not met their burden of proof. Then it goes on to say here, a reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in the case. Proof beyond reasonable doubt, therefore, is proof of such a convincing character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. So this definition is what I'm used to practicing with. And this is something that I talk about and weave into my closing statements and arguments, which is if you have a hesitancy to act on something very important in your life, what's most important in your life? Whether you're going to get maybe some kind of major surgery where you're going to have maybe, let's say, brain surgery or not. Is it safer to operate on your brain or not? Which doctor are you going to choose? And think about it. If you're going to get brain surgery and you went to a brain surgeon, what if they had 3.5 stars on Google? Would you want to go to somebody like that? What if they had a 5-star review, but one of the stars said that it was a minor operation and they killed their daughter? Would you have reasonable doubt about wanting to use this guy? So what about if you're same thing about building a house? Would you go to a house builder that had 3.5 stars, had some 5 stars, had some 2 stars, 1 stars? They're sort of all over the place. That could be the kind of evidence as well. So weave this into your argument on these are reasonable doubts about hesitancy to act in most important affairs, like surgeries or what house you're going to buy or what car you're going to buy. Cars are important, major decisions for a lot of people, maybe not so much for some, but things of like also marriage, who you're going to marry and stuff like that. If you have reasonable doubts, then would you pursue that? So these are the kind of things that, reasonable doubt can be explained away with a jury, but they definitely need more than an hour or even 90 minutes to have this kind of thing explained to them. And you got to weave in all these different details of the case to explain why these doubts have such prevalence in popping out of the case that you cannot be convinced beyond reasonable doubt. You cannot have such convincing character in the prosecution's case when they botch the crime scene so bad, when they fail to collect evidence in accordance with any minimal standards expected of law enforcement. I mean, you could go on and on and on, all the different issues of this case, all the lies, all the strange oddities of behavior you have from the people in the house. They're odd that night. They're odd the next day. They've been odd ever since. Their testimonies waffling between different testimonies given in front of whether it's grand jury or in trial 1, and now we have trial 2. So there's going to be a lot of things they're going to highlight, that the fact that there is reasons to question why are they acting so shady? Why are they throwing phones away? Why are they deleting messages? Why are they up middle of the night? Why is the evidence not consistent from the prosecution? Everything the prosecution has presented for witnesses, for the most part, any significant substantive witness, they have a lot of problems. They have significant problems, and each one of those is a reasonable doubt. You can just go down the prosecution witness list. Each one of those is a reasonable doubt. The defense doesn't have to prove that anybody else was involved. They don't have to prove it through any standard. All it is like, if you think like, hey, do you have a hesitancy to think about why they're acting that way they have done, why they're throwing phones away, why they didn't come out of the house, why Higgins went back to the Sally Port at 2 something in the morning, and story changed on why he went there. Is it reasonable without think why there's some skirmish at the Waterfall bar before they left? Is it reasonable to wonder why it seems so critical for Jen to get John O'Keefe in the house and wasn't texting Jen or calling Jen to find out where they're at? So all these kind of things are reasonable doubts. And so if you had a simple one like this, it'd be so much easier to weave into your argument as a defense lawyer. But you don't have it that way in Massachusetts. And so how has survived all these years, all these decades with this kind of word salad of confusion? I don't get it. But in any event, I don't think it's going to be something that hijacks an injustice on this next case. I think if there would be any kind of a hung jury, I think it's going to come down to the issues that critical evidence, constitutionally required evidence, is being kept out by the prosecutor, Hank Brennan. That's what it's going to come down to. I made a post on the X channel today where I said, truth is like a lion. It can defend itself. You merely have to set it free. Okay? And what you have here is the government knows that having these experts come in is going to set the truth free to the jury, and they're going to see that there's gaping holes in the government's case. They cannot explain it forensically, physically, through physics. They cannot explain it in the various injuries that John had. None of it is lining up with the government's theory. So when you have the physical evidence not lining up with the government's theory theory itself is just some wild speculation that this trooper Paul made up, is how this body of John O'Keefe went flying 30 feet in the air, got launched by just hitting a mere arm, and then you have those kind of dog bite looking arms in the dog bite type of injuries on John's arm. And so all those kind of things are reasonable doubt. The government just doesn't have their act together, and they know it. And the reason why there's all these motions to keep out this evidence from the jury is because they know they got a case that's absolutely ash and trash. Okay, they don't have the kind of evidence to stick against Karen Reed, but they know if they keep out this evidence, they can bamboozle and trick a jury into getting a conviction. And if they get that conviction, then it's game over. No matter what kind of ruling the courts higher up say, well, you should have, this is reversible error because you didn't comply with constitutional requirements. So we're going to reverse this case. They always got their person to stick it on. They can pin it on the girl, as AJ described. So with that, I would say the this burden of proof and reasonable doubt is so critical now to this case, and it is sort of scary to think what we heard from specifically this Ronnie, who talked about the different things of how the jury was just not following in their roles at all. Okay, so if we have another jury like that, they don't even know their roles, they don't know how they're supposed to follow the law, then there can be problems. I think that worse it'd be a hung jury, but when you have convoluted jury instructions, especially on reasonable doubt, you got to do a lot to try to dig yourself out of this hole as a defense counsel. So with that, that's my summary for tonight. Let me check something here. The So what it boils down to is reasonable doubt is simple if you compare it to this instruction I said earlier. In fact, in Texas and state courts, reasonable doubt may oftentimes not even be defined. Okay, so I think it's better to have a definition. But when you got a definition that's all messed up like that, so reasonable doubt is simple. Massachusetts is making it very complex, and that's not helpful to the defendant. Okay, it's not helpful. They need to try to streamline it, make it clear and concise, or not even define it at all. That would even be better. So, and they better be alert for Brennan using some kind cherry picking these kind of points, and they need to really, really counter that in a major way. Because think about it, they only get a chance to argue once. Brennan gets to argue twice. He gets to do rebuttal. All right, I'm going to go back up to your comments. Yeah, you have questions. I prefer you put them in red emojis, the question mark red emojis, because it's easier to find. So if you got a question from them, I'm going to go all the way back up the top. Okay, I'm at 831 there. Yeah, they've got 15 jurors seated. They have, I believe, one more to go. I've heard between 16 and 19. I really think they need more than at least 21 or so. Having folks around for 2 months, they could easily have people drop off. I'm not comfortable with anything under 21. Just scrolling down as fast as I can, looking for your comments. All right, Sam, you're asking what did the judge mean by moral certainty? Well, we sort of covered that here tonight, but how can anybody remember that? Even if you thought you understand it for a moment, jurors going back there, it's like, what does that really mean? And so women, maybe they're just going to revert back to, well, the judge even said it's hard to define, so why don't we just use our own understanding? So that's just, man, that's just really bizarre. And then here, Kim, you're saying I resent that the judge says she'll teach the jury the law when she has no respect for law herself. Yeah, the constitutional requirements do not apply to that courtroom in so many ways. Yeah, special KL distraction equals reasonable doubt. Yeah, exactly. That's something that Ronnie didn't understand. That juror named Ronnie. Blue Lays is saying it's hard to imagine not understanding reasonable doubt, even though I know that clearly happened last trial. Yeah, it's bizarre. How can this be happening? You sit that long through a trial and you don't understand reasonable doubt. What up? You're saying the biased judge says it's hard to find it because she's manipulating the jury. She's following a script, so I don't blame the judge for that. But maybe she feels she's not allowed to deviate from it. If I was a judge, I'd deviate from that. I would, unless you got in trouble with the higher judiciary in your state. This is a hot mess. Carrie B says, heard that jury instruction in the courtroom next door today. Reasonable doubt is well understood, yet not easily defined. I got to disagree. I don't believe it's understood. Yeah, I mean, how can you understand it when it takes you a page and a half to try to describe it? It's just two words. Nacho Mama, you're saying I feel like they pick a foreman to get the jury to follow that person. I think that's what they do. It's sort of like the lead dog of a sled operation. They wanted to carry him through. Sally Williams, this judge will do anything she possibly can to throw the case. That's what it really looks like to me. I don't trust anything going on in that courtroom between the judge and also the prosecutor. What up? You're saying common sense, reasonable doubt means that you could have been another reason something happened because you're not sure that's it. Yeah, you're not sure what the prosecution is saying is legit or not. Dusty Blue, it's amazing to watch Judge Bev be so extremely biased, controlling. I've never seen a judge like her. It's off the charts. Yeah, it is. I've never seen anything that severe bias like that. Clerk Jim Clown's list saying it applies to judge will evolve their understanding to mean I hit him, I hit him, I hit him. Yeah, so she's gonna try. It looks like. Anna's asking, do I know anyone at the State Department that can look at this case as a persecution? Well, I used to work at the State Department some years ago. And I can tell you they're not interested in domestic affairs like this, but maybe mean Department of Justice. And Department of Justice initially started looking at this case and how maybe there's other things going on, just like in the other murder case that's done by a cop that this Canton Police Department swept under along with state police. So, yeah, unless DOJ does something to go after this, I don't think there's going to be anything that is going to be done. Karen needs to be acquitted, and the people need to vote these people out of office. Okay, that's plain and simple. These people don't deserve to be in the positions they are. Leslie, and you're saying they need to hammer reasonable doubt unless on the conspiracy something happened after she dropped him off. I agree with that. Yes, as I've said, I would not focus on who did it so much as there's any number of things that could have happened, and rather than trying to come up with the exact thing, because all of us could come up with a different explanation what happened, right? So rather than pitch yourself into one exact scenario, what happened, then it's sort of like a juror could look at it and go, well, I don't believe that theory. So all these other possible theories of other explanations, I'm not going to believe that. And so therefore I'm going to believe the government. It's sort of like you're pitting the two against each other. So leave all these different avenues of doubt open rather than singling out three people to say who did it, or two now if the judge restricts them on that. Melanie Gore, you're saying the defense needs to hammer home what reasonable doubt is throughout the entire trial. I think between Proctor, butt dials, cell phone data, ARCA, all that alone is reasonable doubt. Yeah, it's massive amount of reasonable doubt. Sean Thompson, you're saying watch out. They also lie to the jury. Judge will show the jury her way of the law. That's what Hank is about in one word: their way of the law. Yeah, Ashley, you're saying example of reasonable doubt to help keep it in perspective. Your decision needs to be so surely made that in 1 year, 5 year, 10 years, you'd still make the same choice regardless of what else is presented. And that's something that I've that I use as well, as a defense attorney, where I say that same kind of thing where if you have any reasonable doubts, you better have them now, because if you have them the next morning after your verdict is announced, and you try to change your vote, then it's too late. The district attorney's office isn't going to listen to you. The judge won't listen to you. The only thing you'll have to clear your conscience is to hire an appellate lawyer, and who can afford that? So you're right on with that point. Eve says, it seems like the Commonwealth wants to confuse juries. I totally believe that's the strategy that they want to do. Unless he rests my case, says, how can Brendan bring in any of the interviews without Karen on the stand? Well, it's called admission by a party opponent. So I think what they should do is maybe argue that it's not an admission of anything if they're just saying what she was talking about or whatever, if they can get away with it being not being a technical an admission of anything, like an admission of guilt in some way. So if it's not an admission of guilt, then you can argue that it should be kept out. But with this judge, she's going to let everything in the prosecution wants for the most part, unless it's going to derail the trial, because lawyers have to be withdrawn. It's coming in pretty much for the prosecution. And the defense is pretty much hamstrung. Their most critical evidence, she's going to try to keep out. Dusty Blue, a biting conviction. Any layperson will be so confused by this. Hello, keep it simple, stupid. Well, that's the way, judges talked back in the 1850s. So for them to still expect jurors to keep that explanation. BBR saying this is well-oiled corruption. Bubsy saying some of the language is similar to that to Casey Anthony's, but not the moral certainty verbiage. Other states in the East Coast, it's more of an East Coast thing. I have not seen this in the Midwest. Matilda, you're also talking about just keep it simple with reasonable doubt. I agree. Okay, I'm up to 9 o'clock now. Leslie Barrett, you're saying you didn't realize how confusing this is previously. Yeah, I mean, it's very confusing, not helpful at all. One of the things I can tell you as a defense attorney, you want to have confusion generally favors the defense, but not when it comes to the law and jury instructions. You do not want anything confusing about jury instructions, okay? If you want confusion, confusion can lead to reasonable doubt. So that's something you want to strive for as defense counsel, but you do not want jury instructions being confusing to the jury. That is not a benefit, especially when it violates due process like this is. Yeah, Attorney Berto says Senator Massachusetts beyond moral certainty. Yeah, I've said that. That's like a standard jury instruction. So it doesn't mean it's right. And just because they've been doing it for I don't care how many hundreds of years, it doesn't mean it's right. It doesn't mean it's constitutional. Yeah, LA saying they need to dumb this way down. It's shocking how few people, including jurors in trial, won't understand reasonable doubt. Like this common refrain, she probably did it, she's guilty, but probably is not guilty. Yeah. They mentioned probably a number of different times. And they have multiple definitions of reasonable doubt. So how do you argue that as a defense attorney? Which standard is applicable? You have multiple standards in terms that are very antiquated and confusing, and you try to link them together, and it's just a hot mess of word salad. Patricia DeBrow, thank you. You're saying you're giving you're I'm giving you an excellent critical approach to this troubling case. So yeah, I tend to cover it the whole trial as much as I can. Not every day here while we got jury selection going on. Carrie B, you're saying entitled is negative language too. Yeah. So when it's talking about entitled to something, it does sound like you didn't earn it. It's not really a right. So that's a good point. James Lynch, you're saying that man was beaten inside the house by Brian Albert, Brian Higgins, Colin Albert. Okay. That's what a lot of people are thinking. And if you think that, if you're on the jury and you think that's what happened, what proof do you got? You don't have any really direct proof. You have some circumstantial evidence that makes it look like they're trying to cover something up, right? But you got no direct proof. You can't say which one really did what. You don't know what happened. If you don't know what happened, and you know the government's theory of what happened is not supported by the evidence, that's reasonable doubt. It's massive reasonable doubt on so many levels. Okay, Aaron, you're saying to me a moral certainty means as sure as I would be as if I witnessed it with my own eyes. Okay, I don't think the standard means to be that high as if you're an eyewitness to the crime. But like I say, what it gives that was a stronger part of it, but then it goes on to define it into more confusing terms, and then it's coupled together with other different types of definitions of reasonable doubt. So overall, yeah, you may think that, but the other juror may think, well, the judge said it sounded, it's hard to define, and we all sort of know what it means anyway, and it's using about what in my mind I think there is, and if in my mind I think they're guilty, there is some evidence that they are guilty. The prosecutor is arguing that the person's guilty, so therefore, I'm perfectly morally, I have a moral certainty that I'm doing the right thing by voting a conviction of guilty, and that's not what this is about. That's why this whole jury instruction is needs to be ripped up, and they need to start over. Yes, that's the same form used in every case. Correct. Libby C saying half of those keywords are subjective. Thanks for joining us, Melanie's popped off head. Lisa Louise is saying isn't moral certainty in the Massachusetts law. Yes, I'm reading from the law, the jury instructions, but for what it's worth, I mentioned this last trial. Whose morals are we talking? That could be 12 different answers in those deliberations. That is true. But that is also the way jurors look at evidence. One person's reasonable doubt may not be another's. Everybody could have a different reasonable doubt, but if they all agree there is a reasonable doubt, they don't feel sure enough to convict, then that would result in a full acquittal. Ellie, you're saying I felt her, obviously, Judge Cannone's bias here at the opening statements. The first I learned about the case, she started with constant sighing every time defense spoke. So not so subtly telling the jurors that she doesn't respect them. Yeah, that's very disturbing. There's a whole lot of other stuff's going on besides just the sighing. Selina HM, you're saying probability is based on scientific or evidences, but reasonable doubt is based on intangible moral ground or motive or intention or doubts. It's also tied into evidence. So anyway, it's just very much, very much. Everybody's going to think of something different on this, right? With this current jury instruction, everybody's going to think the standard is different. They're not. It's just opening the door to so many different interpretations. Oh, always says a sign is needed. Reasonable doubt equals any questions or unsure that it happened as Commonwealth states. Well, that would be better than what they have right now for jury instructions. Carrie B, it's so messy they abandon the instructions, go with their feelings. I mean, that's the thing that I'm saying. These sort of lead to that conclusion because they talk about what's in your mind and they don't really tie it to the burden of proof and the elements. Each and every elements have to be proven beyond a reasonable doubt. It's just not one of them. You just can't think somebody's guilty and vote them guilty. There's got to be very solid proof of that. Melanie Gore, you're tired of sighing as well. Leslie's verbal pharmacy says, I've heard someone say it would be better to call it a mortal certainty. Would you bet your life on it? That's a good one. Would you bet your life of someone you love on the evidence? That's a better definition. I like that. Oh, Sam, you're saying, well, that's the way we've always done it in Massachusetts. Yeah, that's along the lines of what Judge Cannone was telling the defense when they had problems with the verdict form. Sharma Lily, you're saying, in my opinion, it's purposely confusing and feels like a setup for failure. Why don't they change? Why does the legislature do something in that state and change the law on this jury instruction? Nancy, you're saying Webster's definition of doubt, especially about the guilt of a criminal defendant, that arises or remains upon fair and thorough consideration of the evidence or lack thereof. That's a much better definition. I'll take that any day rather than this one that we have in Massachusetts since the 1850s. Tall Glass, you're saying, I hope the defense comes in hard pressed. Melanie Gore, you're saying jury one totally dismissed ARCA because they thought the insurance paid for them. They aren't supposed to try to solve the case, though. It makes you feel sick for Karen. She should have gotten a more biased. She couldn't have gotten a more biased judge. Yeah, I totally agree with that. And that's why they want this evidence kept out from ARCA because they know that's going to be a slam dunk, even more of a slam dunk win if the jury does not know that the FBI, U.S. Attorney's Office hired them. Lisa, Louise, you're saying AG always thought those jury instructions were sketchy. Judge Cannone says that's how we do it in Massachusetts. Yeah, that doesn't mean it's right. Yes, they are awful. Fellow law. Jury instructions are awful. Great chick, I worry that given the confusing instruction in this case, there will be another hung jury. That's what this is. That's what this is setting up. Yeah, this can set up a hung jury with this kind of garbage for jury instructions. And that's why, as a defense attorney, you have to overcome this. If you can't get this whittled down to something simple on what reasonable doubt is, Mad 962, you're saying you're hoping I am correct, but if you don't get all the evidence, how can you make a fair decision? Yeah, well, that's exactly the prosecution doesn't want a fair and full considered decision by the jurors. They want to keep the best evidence showing that Karen Reed is not responsible, not guilty of these charges. They want to keep that away from the jury, and that way they can hijack the truth and ramrod a bunch of one-sided evidence, cherry pick stuff, confuse the jury, use these ridiculous instructions, and just hope that they can trick a jury into believing this garbage that they're presenting. PH 1964, this reasonable doubt paper will bamboozle and discombobulate the jury. It's deliberate in my point of view. I think it probably, if it was written by this judge in 1850, all this reasonable doubt language, and they've been copying it ever since, apparently. And so this is a guy that liked to hear himself talk and write, I think, and that's why this got translated into jury instructions, because jury instructions are supposed to be clear, concise, to the point, and this is anything but. I just cannot believe it survived all these years. A desire for civil discourse. Thank you. You're saying that the entire point is persecution, and the judge seemed to be to cooperate in confusing the jury and belittle the defense, so they just assume that the person charged must be guilty. That's a good summation. I totally agree. And it's so disgusting to see. Complete disrespect to John O'Keefe and his family, but his family apparently is just on this track that the government's telling the truth and the government's all about honor and integrity and pursuing justice. It's not. It's not at all. Melanie Gorey saying you knew nothing about this trial beforehand. You didn't think they proved their case. I am a not guilty. I guess that's your belief still. But whether you think she did or not, so much reasonable doubt that she couldn't be convicted. Yeah, it doesn't matter whether you think she did or not. I know people have asked me what I think really happened. It doesn't really matter what happened, and I wouldn't be trying to argue this is exactly what happened. All I can tell you is that whatever the prosecution's saying, that's not the truth. That is absolutely not the truth. It's something else happened. Yeah, Ashley, these are you're saying inverted video, botched investigation, Google search at 2:27 a.m. Reasonable doubt is so many examples. There's just oodles of them. Rosemary Gallagher doesn't like the word possible or possibly. Carrie B saying the butt dials that night alone are not reasonable. Yeah, they're not reasonable, and it causes reasonable doubt. I agree. Annie Level is asking, do I and some of the other lawyers I listen to ever write to the Attorney General of Massachusetts and voice your concerns, or is that something that can't be done? That is such a, they don't really care what some out of state lawyer is saying or some YouTuber. They don't care about that. DS on YouTube, you're saying, I honestly believe the state is still heavily influenced by the old British Parliament. It's all being so convoluted with words on paper that drone on and mean nothing. Yeah, maybe there's some truth to that. All this lofty language that This is nothing but unintelligent dribble. Ashley, you're saying you think that voir dire for ARCA before they testify, you think that's going to be a staged scenario? I think that's what she's trying to do. She's trying to give the prosecutor every chance he can to try to find some kind of bait them in some kind of trick, catch them in some kind of misstatement, and then argue that they're a bunch of biased liars and just try to smear their character and reputation. I mean, it's just despicable. James Lynch, you're saying put 12 people with street smarts on the jury. Yeah. Anyone with any kind of street smarts would see right through this. PJ, my concern is the verdict sheet. It's confusing on purpose, it seems. It sure seems that way to me. John Bew, 1981. You're saying this judge is in on the cover up. Well, the judge's ruling had the same effect. I'm not saying the judge has anything to do with being a part of a cover up. I'm just saying her rulings make it look like she is so far doing everything she can possibly do to try to get Karen Reed convicted. And that's not the role of a judge. They're supposed to be neutral. Ashley, you're asking how can the defense challenge that verdict sheet if the judge still had the same form from trial one? Well, I think you better show how the jury was so confused that's why we got a hung jury. We need better clarity. And I think they could make some kind of motion and talk about how other jurisdictions do have a better explanation of reasonable doubt, or just have no explanation of reasonable doubt. You'd be better off than this hot mess you have here. Malcolm Rich, you're asking, do I think that, and the others as well on this, do we think that Judge Cannone and the prosecution is setting the stage by subtly influencing the jury for a conviction later on? I think there's all kinds of things going on from the start of this case all the way to finish. There'll be stuff that the prosecution's doing, the judge is doing to try to bring down Karen. It is so obvious. But whatever spin you want to deny legitimate constitutional evidence from coming in, that's the only way they can get this win. But even that is not going to work. Karen will not be convicted. Britchick is asking where are all the Massachusetts lawyers? Why aren't they speaking up about this? What are they afraid of? You know, a lot of people just don't care. A lot of lawyers, they don't care about whether their clients are going to be wrongfully convicted or not. They just want to get their money. And if it's not their client, they can care less. They're just trying to work their own job. They don't follow these kind of cases. It's just irrelevant to them. And if they speak out, guess what Judge Cannone is going to do to them in the courtroom when they have a case? They'll be treated like Karen's team. So they don't want to speak out and have hell to pay. Yeah, any trust you would have had in the Commonwealth's justice system was misplaced. Clerk Jim Clown, you're saying they're not just going to dress the doctored withheld evidence, so it's all a sham. The judge will do what she can to help prop up the government's case that is basically in shambles. Frank Fax is saying that Cannone's jury instructions pinned on the girl. Daniel's DeStefano, CPA, can the Supreme Court step in and stop this before it gets worse? No, it's courts don't intervene in the lower court unless they did like a writ of mandamus to try to force this judge to do something different. That's the only chance. Certain instructions that they wanted her to rule on that she ruled against them on. I would do it for sure on like keeping out the expert, and also if she tries to keep out the ARCA witnesses, I do it also for the letting the jury know that ARCA was hired by the feds. That kind of stuff I do a writ on. Full Melt, Hash Valley, saying the Commonwealth even wanted defense to assert all their edited doctored evidence in writing. It's discussing how disingenuous the Commonwealth is being in this persecution. Yeah, I've never seen anything like it. This is bottom of the barrel, absolutely insanity. GP Dog Drool, this case is nothing but straight up corruption. Jane Ferguson, you can try to appeal it, but it's pretty much already been decided. This kind of language is not going to be appealable as being a violation of due process. But that last was decided by the Supreme Court in the mid 90s. So I think maybe they should give it a shot again. It may be a stretch, but why not give it a shot when you really break it down like this? You see how crazy it is. PJ says, any thoughts on the verdict sheet? Even Davianetti agreed he has seeing like that before in Boston courts. Yeah, there's the system was rigged. So if this wasn't standard verdict form, then yeah, I can't explain that on the fact that they got to try to maybe do a writ before it goes to the jury to try to have the higher courts do something to change this mess. Annie Lavelle, you're saying you're so upset. What can we do to not let a poor girl spend her life in prison over bad cops, bad judge, etc.? Well, just keep spreading the word. And if you do want to help them out financially, then look into. I know there's a number of different places you can support the defense team. They're all working pro bono. That's one thing I would do if I was there as a defense attorney. When they stand up and they introduce themselves to the court, I'm good morning. I'm a pro bono counsel, Carl Steinbeck, representing Karen Reed, and let them know. And all the attorneys stand up and say we're pro bono, and they're going to what? Because I guarantee you, jurors will think that the Reeds are mega rich and they hired all these lawyers because they know that Karen Reed's going to go down unless they get this army of lawyers there. And so they need to neutralize that thought from occurring, because some jurors will think that. I've seen it before. So they need to neutralize that by explaining that they're all doing it for free now. I know they got some fund sources coming in, where that's going and whatnot. So to the extent any of them are free, I would make sure that you're accurate on that and be truthful. Obviously, you don't want to mislead a jury if it's not actually true. But if it's true they're all working for free on this second go around, they're just paying for expenses. I would clarify that. Thanks, LA. It's pretty obvious. Mr. Monks, I understood you're saying today on the Young Jerks, former FBI Rob D'Amico said he thinks the defense should pick strategically the many pleas errors, or it becomes ineffective, basically like they did in trial one for the juror. So you're saying here defense should pick strategically the many police errors, or becomes effectively. I don't know what you exactly mean by strategically pick them. I mean, they need to really make them a big deal in the cross examination, especially if they can't bring an expert in. But I'd keep fighting to bring that expert in, that FBI agent for the defense. Leon, lately you're asking, it's obviously a botched case. Can another state intervene and question these charges? No. Each state is its own separate sovereign, other than the federal government being above them. And the supremacy clause makes the federal government and its power, for the most part, surpasses that of the individual states and collectively the states. Or can the attorney general's office not intervene because the world is watching? You would think somebody would intervene, but they're all part of the same party up there. The the same party's in charge of the House, the Senate, the governor, the DA's office. So they're all entrenched, and they don't want to. They're not going to get involved in a shootout against each other when they're all on the same side. They're all in the same political party. Two doors down, you're saying it seems to me the DOJ told ARCA to send their findings to shut this down, but it's so deep that they either don't care or aren't smart enough to figure that out. They haven't figured it out yet. Yeah, they're not. That should have been a wake up call. It's like, wait a minute, ARCA is saying this is not a possibility, that the damage to John O'Keefe's body came from Karen's car. We're not going to go to trial on this one. That should have totally changed the trajectory here, but it didn't. This is all about politics. JP Dog Drool says this case is nothing but straight up corruption. Rosemary Gallagher, that's a good point. When you have a majority of people in the Commonwealth and across the country believing Karen is innocent and the Commonwealth is corrupted, you should have grave concerns. Thanks, Ruth. Christie's saying I should get in there. Defense counsel, I think they have enough, so they wouldn't be interested in me. Oops, I just lost Just lost everything. Oh, there we go. Okay, the whole screen is disappeared. Okay, Kate, you saying they need Sergeant Murphy, retired cannon sergeant. Yeah, that'd be great if they had him. Mr. Monk's understudy saying Morrissey's BFF John Connolly lost huge last night in the Canton Select Board election, 36-year incumbent out. Yeah, that's what they got to start doing. Get rid of all these entrenched political hacks. PJ, I agree. When they had to bring in an outside prosecutor for this case, it just reeks more of corruption. The fact they know they got a loser of a case, but what a better guy to try to prop up this garbage than Mr. Brennan himself. Tam Jules is saying, I think it's the very first case every single lawyer on YouTube is united in calling it the foul stench of bias and corruption. Yeah, it sounds that way. People in court, you're saying if they decide to get extra alternates, will the defense get more strikes? Yeah, if you have more alternates, you would get more preemptory strikes and more for cause challenges. Okay, let's see. PBR saying is so much reasonable doubt almost a detriment to the defense. I think from the standpoint that if you tell a lie frequent enough, eventually most people will believe it, kind of thing. So from that standpoint, it's like, how can it be this weak of a case that the prosecution is bearing? How can they stand up with a straight face and say this is how John O'Keefe was struck by the car? They have no idea exactly where his body was. They don't have and how it got there. It could have been moved any number of times. They don't have any details. They're just making stuff up on what they think happened. And so it's so weak that, yeah, you could have jurors thinking, well, we don't really know what happened, but we're just going to trust the prosecution. And there's just so many different things the defense is bringing up. We're sort of confused by it. It's more of a distraction. So yeah, if they look at it as a distraction, like that one guy was saying, some of them did, then that could be a detriment. But I think I just got to believe that the next jury is going to be able to be honed in even that better on what the law requires, what reasonable doubt is, and that's going to help carry the day. Kate saying, as John was invited to the house and Jen, the lookout from the window, telling them where to park, was anyone questioning where are your texts? Was anyone questioning where are your texts? Asking John, where did you go? Yeah, I mean, what took them so long? And why wouldn't they? Why wouldn't you called up Karen and said, Karen, what's going on? You guys should have been here by now. And if her car's out there, call her up or walk outside. All that's super fishy. Maya Rodriguez Sorensen, a lawyer, saying, what I don't understand is how people who aren't in Canton or even Massachusetts are so convinced Karen Reed is guilty of hitting him with her car. Well, I'd say they haven't followed the case enough, or maybe just don't like her for personal reasons. Maybe they find her to be somebody they like to hate. Maybe they're jealous of her or something like that. Mr. Monk's understudy, you're saying you agree 100% about telling a lie enough to become truth. That relates to what the FBI agent was saying. Jurors don't think judges allow non-China evidence in a trial; they think it's legit. Yeah, that can be a real problem if you got juries just rubber stamping whatever the government witnesses are telling them. Okay, I'm just going to go for a couple more questions here already. 10:12 Central Time. BC Natalie, you're saying John was already hurt, and while Karen was sitting outside waiting for John, they were hoping she wouldn't decide to go in the house. If that's the case, well, if that's the case that he got taken out in the house, then what do you think would have happened to Karen if she went in the house? That would have been really something. So many people think John got attacked in the house. So that's a real common belief. That's the defense's theory. So how they can get 12 jurors to disbelieve all that when so many of folks covering this across the country and across the world just don't think that the evidence is there to support it. In fact, there's more evidence to show she did not do that. Bosch investigation. That's a funny dream. He had a dream the court was in section and men in black interrupted the court session and authoritatively told Judge Cannone to put her hands on her back and whisked her away. JC saying it's so obvious that nothing comes together to pin anything on her. Too much doubt about every single witness for the prosecution. I agree. Thanks, Lacey. That's funny. All right, with that, I'm going to go ahead and wrap it up tonight. Y'all have a great rest of the week. And Friday night, I intend to go do a live stream. I'm going to have a medical expert talk about the injuries of John O'Keefe and how that also is just rampantly full of reasonable doubt as well. So probably looking at 7 o'clock on Friday night. So that's 2 nights from now. And so hope to see y'all back then. And keep spreading the word about this case, about how Karen Reed's being railroaded. And that's the only thing that can ultimately change things beyond this trial is pressure and the vocal outrage and disgust being projected to Massachusetts and letting the folks know that, you know what, we see what's going on around around the rest of the world. We see what's going on, and we do not condone that. We do not support that, and we're speaking out about it because it is wrong. Not only is it wrong, it's evil, it's immoral, it's unconstitutional, it's all those things and more. So thanks for y'all for supporting the cause of justice, and we'll see you soon. Thanks. Have a good night.